Welcome, really good to see you this morning for our immigration update webinar. There's our details of your presenters today, myself and Mark. So if you'd like to link in, do that. It would be great to have you on our network. So it's a really interesting and I think tragic time for the kind of immigration landscape at the moment. Obviously, Ukraine is featuring heavily, and I'm sure our thoughts go out to all of the difficulties that people are experiencing and the tragic situation that's going on. On the UK front, it's quite an interesting time as the government continues to roll out its new plan for immigration. It launched last year, which it likes to describe itself as the marketing of global Britain. So lots of changes happening. Quite a bit of heat in Parliament in the past couple of days with the Nationality and Borders Bill and questions about, well, how open should the UK be to those seeking refuge from difficult situations. We obviously can't cover everything today, and I appreciate lots of those issues are not really relevant to us in our day-to-day work. So what will we be doing this morning? Really just looking at three areas in the hour or so we've got available. So we'll spend a chunk of time, Mark will do this, looking at changes to right to work checks, which are being implemented from the 6th of April this year, so imminently. And a few other changes also happening a little bit later in the year. So Mark will talk us through those for 15, 20 minutes or so. We'll then spend a bit of time looking at new immigration routes. So there's been a statement of changes published on the 15th of March, marking some quite substantial changes to the immigration system and new routes kicking in from between the 11th of April this year and the 22nd of August. So we'll look at those routes, how they affect employers, what the opportunities and challenges might be, and we'll finish up with a bit of a roundup and a bit of a focus on Ukraine. So think about some of the other news and developments that are happening on the immigration front, look at the impact of Ukraine in terms of the routes that are open and also the impact on the services that businesses are using at the moment, and a bit of a scan, look ahead for what could be on the horizon. We'll try and be done a minute or two before 11 a.m. so we can get a cup of coffee before the next meeting. We'll send out the slides after the session with an email, so you will get those. If you'd like to raise some questions, please feel free to do so. Could you pop those, please, in the Q&A function rather than the chat function, so we only have to look at one. We have got a very large number of people on this webinar, I think more than 1,000 people. So it may be that we can't look at your particular question today, but we'll do our best to scan those and pick up questions and themes at the end. Okay, so without further ado, over to Mark for a bit of a look at changes to right to work checks. Mark.
Yeah, thank you, Alex, and good morning to everyone. So we're going to start by looking at right to work checks, and as Alex has already mentioned there, the imminent changes that are going to be coming in from the 6th of April. To begin with, though, probably worthwhile just providing a bit of an overview, just by way of reminder. I'm sure many of you on the call will be familiar with how right to work checks operate. But in terms of the current system, there's a few ways that you might be running right to work checks at the moment. So you may, for example, be conducting a manual right to work check. That is a physical inspection of a document and sort of the old school way of doing it, for want of a better term. You have a passport, for example, in your possession. You physically look at the passport, you take and retain a copy of said passport. So that's one option that's available, and particularly you'll be using that where there are no alternatives. So you can't, for example, use an online check instead. Which then brings us to the online check. So you may be conducting an online check, which is really the same process as a manual check in terms of what you're doing. But instead of looking at a physical document, you are looking at an online status. And as we've covered in some of our previous webinars, this really came about in conjunction with the EU settlement scheme. So individuals who have status under the EU settlement scheme were not given a physical document. Therefore, you as an employer cannot check a physical document because it doesn't exist. So instead, you do an online check. So that's available for those who have status under the EU settlement scheme, and also for those who have biometric documents or perhaps status under the points-based system, so skilled worker visa holders, for example. And I'll come back into that, onto that, in a moment. And then finally, you may be in certain circumstances actually making use of the employer checking service. So this is a system that is available where you cannot conduct a manual check or an online check because the individual is between visas. So they had a visa to live and work in the UK, whatever that visa type might have been. They've submitted a fresh visa application to renew that visa. But at the moment, the application is still with the Home Office. So they don't currently have a visa. Their new one hasn't been granted yet. Their application is pending. In that scenario, you would be using the employer checking service to essentially go to the Home Office and say, well, does this person still have a right to work? And the Home Office will respond with a verification notice. And if they do, it will be a positive verification notice, which is essentially the Home Office saying, yes, according to our systems, there is a pending application that we are dealing with. Therefore, the right to work does continue and you can continue employing, and you'll have a statutory excuse for 6 months in that scenario. The idea being that within the 6 months, you will be able to then conduct either a manual or an online check once their status has been confirmed. So that's kind of the background, the overview, if you will. In that context, let's have a look at what is actually changing. So the main change comes to that online check system. And to provide a bit of additional kind of background to how this works, and just to bring everyone up to speed, the online check is kind of initiated by the migrant themselves. So they are able to access their status online. And in doing so, they are able to generate what is called a share code. That share code is then used by you, the employer, in a separate part of the Home Office system, whereby you can insert the share code, insert the individual's details, and that will provide you with information about their right to work. And as many of you will know, what actually happens when you put that information in is you are greeted with sort of the normal information you would expect of a passport or a visa. So there'll be the photograph of the individual, their name, personal details, and whether or not they have a right to work in the UK. So that's how the online check operates. The share codes are now valid for 90 days rather than 30 days. So that's one change that's been implemented there. And additionally, the share codes are now kind of additionally codified with a W at the front. And so the reason for this is that the system I've just described is available not only to employers, but also to landlords, estate agents, for the purpose of proving an individual's right to rent. That system has a separate share code. And so when you are making an online check, you need to ensure that the individual has provided you with the correct share code. The way you now do that is by checking whether there's a W at the front of the code. If there is, you know that the person has got it right and sent you the correct code. If there isn't, all that means is they've sent you the wrong type of code and they just need to go back into the system and generate a code for right to work purposes. Okay. How is that actually changing then? So from the 6th of April, that entire system that I've just described is going to be the only way for you to check the right to work of those who hold a biometric residence permit, biometric residence card, or frontier worker permits. And as I've already said, this is already applying to EU nationals under the EU settlement scheme. So what we're looking at, really broadly speaking here, is from the 6th of April 2022, for migrant workers, i.e. those who hold some kind of visa or status, you're going to be completing an online check. You're not going to be able to check these documents manually anymore. And to give a practical example, the difference here and the way this is going to operate, if you were checking the status of a skilled worker visa holder today, you would be able to conduct a manual check if you wanted. You would be able to check their biometric residence permit and complete a right to work check in that manner. Or they could, at this moment, log into the system online, generate a share code, and you could complete an online check. So currently, both options are available. From the 6th of April, it is only the online check that you can use and rely upon. And that is the case regardless of whether or not the biometric residence permit itself remains valid. So perhaps that skilled worker has status until, let's say, March of 2024. That's fine, their biometric permit is valid, but you still need to be conducting the online check from the 6th of April onwards. One important point there is that again, using that scenario, if you were to conduct the check today, you don't need to, on the 6th of April, then conduct a retrospective check in relation to that individual. Checks that have been completed already and were done so according to the guidance at the given time are still valid. So this is only moving forward from the 6th of April onwards. Those who have a visa, you're going to be conducting an online right to work check. Turning now to a brief update on COVID and the adjusted checks that were implemented as a result. I'm sure many of you are familiar with these checks and how they operate. And again, this is something we have covered in our previous sessions. Just by way of reminder, the adjusted checks for the purpose of COVID really are there to facilitate right to work checks in an environment where many, if not all, workers are based at home. And so essentially the adjusted check is a manual check. You are checking a document, but you don't have to physically hold that document. So if we use the example of a British passport, when you're doing an adjusted check under the COVID concessions, you don't have to physically have that passport in your possession. The migrant would instead, the worker would instead provide you with a PDF version of the passport, for example, an electronic copy. You check the electronic copy. You do the check in the normal way in terms of checking it against the individual, making sure you're happy that they are who they say they are, for example. You retain a record as you would. But the point is, you can do all of that remotely. And that's an important point as we move forward, just in relation to the COVID checks and particularly in relation to the fact that this has been extended. As you can see there, the extension is to the 30th of September this year. So there was previously an expectation that actually the checks would end on the 6th of April. They have been extended to the 30th of September. And as has previously been confirmed, there will be no requirement to complete retrospective checks after this concession ends. So any checks that have been completed on the adjusted basis will still stand. I think what we will then see is an implementation of quote unquote the normal rules from the 1st of October onwards. And the reason that I think that's going to be the case is because of the introduction of the IDSP. So just before we get into the detail of the slides, to summarize what's been said so far and what these changes actually mean. From the 6th of April, we are going to have a situation whereby migrant workers, those who have a visa of some type, are going to be subject to the online checks. That's what you're going to be doing for them. But obviously, most right to work checks will involve British citizens or indeed Irish citizens who by virtue of their nationality have a right to work in the UK purely on the basis of their Irish passport. And obviously for those individuals, you're not going to be able to use a share code that's generated by the Home Office because the Home Office doesn't have their details. So for British and Irish citizens, it will remain the case that you would be completing a manual check, i.e. you will need to be looking at their passport as you always have done and completing a check in that way. But this new policy, the change and the move to online checks really is an example of how the Home Office are kind of pushing digitalization. And so what we have in accordance with that sort of policy decision is the implementation of the identity service provider checks. So the way this works is that a third party will conduct a right to work check for you in relation to British and Irish citizens. And so from your perspective as the employer, you're not looking at a physical document because actually the check is taking place with a third party and they're providing you with the details after the fact. However, as we've noted on the slide there, although a third party is providing you with the information and conducting the check on your behalf, it is your responsibility still as the employer to make sure that the check is correct and that it complies with right to work guidance. And additionally, that actually the process that the identity service provider is using meets the relevant requirements of the scheme. And so still a lot falls on the employer, and it's not the case that you can just wash your hands of this and say, well, a third party is dealing with this, so we don't have to worry. That potentially is therefore less attractive than it might initially appear. But there is no need to kind of immediately start making use of this system because of the fact that the COVID concessions exist still and will do until the 30th of September 2022. And what I mean by that is that the COVID concessions, as I've just outlined, allow you to continue to conduct your manual right to work checks on British and Irish citizens, but to do so remotely. And I think realistically, when you boil down this new IDSP system, the main benefit of the system is that it allows you to conduct checks remotely. You're not the one checking, a third party is checking, but from your perspective as the employer, you're not having to get the document physically. You're not having to hold those documents and worry about security issues and the like. It's all done remotely. And so if we accept that the main benefit here is the fact that it can be dealt with remotely, and we accept that obviously those COVID concessions are continuing and mean you can still do this remotely, the result is that realistically, I don't think this system is going to be hugely beneficial until the end of the COVID concessions. And potentially that's why those concessions have been extended, but obviously that's an unknown to an extent. Now, what does all that actually mean for employers? Well, as you can probably tell, it's very much a case of wait and see. This system does have one clear benefit, and actually I think that's potentially unfair, that there are probably other benefits. So for example, if you are an employer who already outsources some of your checks, if for example you require DBS checks of all your workers, you might be using a third-party provider to conduct those checks. Well, if that third-party provider also registers for this system and can offer you this service, you might say, well, actually, we're happy. We're already dealing with that entity. We're happy to continue dealing with that entity and broaden our relationship with them so that they're going to conduct our right to work checks. So there are some benefits there, but they will apply in very specific circumstances. And as I say, I think realistically, it's a case of wait and see. You don't have to rush to use this system. I anticipate, as with all things Home Office, there are likely to be some teething issues. So realistically, if you can wait until the end of September, the beginning of October, and then think, well, okay, are we going to use this? And in the meantime, if it is something that is potentially beneficial to your business, then absolutely keep an eye on things. We've listed there at the bottom of the slide. Further details on the system are available within the draft right to work guidance, which is available online alongside the current live right to work guidance. So something to be aware of, something on the horizon, potentially beneficial in certain circumstances, and certainly one to watch if you think those benefits would apply to you. And then one final thing from me in relation to right to work checks. You may recall that there was a grace period implemented in relation to EU nationals who should have applied for status under the EU settlement scheme. The deadline was the 30th of June to make such an application, 30th of June last year, I should say, but failed to do so. And so on now, if they are making an application, they're doing that late. And from a right to work perspective, a grace period was implemented, which essentially operates to allow the employer to continue employing an individual whilst they submit a late application to the EU settlement scheme. So to give a quick example, if an individual comes to you today, a worker who is an EU national, and they say, well, I'm very sorry, I've just realized that I should have applied to the EU settlement scheme. I failed to do so by the 30th of June 2021. I now realize that I have no status in the UK. What do I do about this? Your answer as the employer is that they must apply within 28 days of notifying you of this issue. Okay, they have to apply to the scheme. Obviously, in doing so, they are doing so late. But having made that late application, they will be issued with what is called a certificate of application from the Home Office. And you, as the employer, can then rely on the certificate of application to conduct an employer checking service to make sure that the individual does have an ongoing right to work. So that concession is still live. That grace period, as it were, is still available. And kind of the final point on that, obviously, we don't have time to go into this today, but there are a huge range of possible reasons and justifications why an EU national might be applying for their status under the EU settlement scheme later than they should. And because that range is so broad, really our recommendation in headline terms is, look, if someone does come to you and say, as I've just said, should have applied, failed to do so, what is my next step? Realistically, it's worthwhile them making an application. The sooner the better, obviously, but that's something that they should be exploring. There's really no harm in doing so. And I'll hand you back to Alex.
Brilliant, thanks Mark. Just to pick up very quickly on a couple of comments and themes from the Q&A. Will the IDSP checks be free? No, obviously the third-party provider will charge a fee for that. That may vary from provider to provider. And will it be compulsory to use it? No. So from the 1st of October, you can continue to do hard copy checks on passports in the way that you have always done if you want to do so. This is at the moment an optional alternative option for doing those checks. Right, so I thought we'd spend the rest of the session, or most of the rest of the session, looking at the new immigration routes, which we've had details published of, all part of the government's much vaunted plan for growth and building back better from COVID, a call to arms. The Prime Minister described it in the foreword to that document. And it's certainly a significant set of changes. It is questionable whether this is a simplification of the immigration rules, which the government has said that it wants to do, but it's certainly opening up more routes, more individual options and more bespoke options for a range of different assignments and scenarios in the UK. So particularly for international businesses, it is going to be significant. So I thought I'd talk through the new routes in a reasonable amount of detail and think about how they might be useful in different scenarios. The first one, which kicks in on the 11th of April, so not far away at all, is the Global Business Mobility Visa, which has been talked about a lot. We've covered it in headline terms in previous sessions, and we've now finally got some more detail. This is essentially designed to cover the scenario where existing routes have been insufficiently flexible, particularly for international businesses in a number of different scenarios. It's been highlighted that the visitor rules have not always been fit for purpose in facilitating legitimate activities of a short-term nature in the UK. And really this is designed to try and address some of those scenarios. It covers both the existing UK presence of a business, so an existing business bringing staff into the UK, and also a scenario where there's no UK business, but people need to come in for short-term activities, perhaps on a service provider type scenario for a client as a supplier, those sorts of things. All of the 5 subcategories here are sponsored routes. So a sponsor license is going to be required for all of these routes. Some of them are a consolidation and rebranding of existing routes, but some of them are an extension and indeed new routes that are quite interesting. So we're going to unpick those 5 different subcategories as we go through. A few general points. The maximum cumulative permission across all of these routes within the Global Business Mobility Visa route is 5 years in any 6-year period, subject to exception for certain high earners for the senior or specialist worker, which we'll come to in a moment. That is a change. So 5 years in 6 years is a big change for some of these routes and options to what we currently have at the moment, where there are much shorter periods effectively in play. None of these routes or subcategories will lead to settlement, so they're all for short-term temporary assignment type activities. Dependents can accompany the main applicants for all of these routes. Again, that is a change for some of these short-term activity routes. And we are still waiting for the policy guidance to be published. I was sweating last night, thinking, is it going to appear overnight? And I was up at Cracker Sparrows this morning just to make sure nothing had been published for a wholesale change to the slides, but we're still waiting for that policy guidance to come out. It probably will land on, guess what, the 10th of April. We'll have to wait and see. So let's run through each of the subcategories, looking at the key features. The first one, essentially a rebranding of the intra-company transfer route, is what they call senior or specialist worker. This is essentially the route we already have at the moment to transfer staff to the UK to do relatively substantive, sort of longer term, if you like, typically roles in the UK. It's basically a rebranding, not a huge amount of change to this route. You still need 12 months prior overseas employment in the group company that's overseas, unless you've got a high earning threshold of 73,900. But the minimum salary for this route is going up as recommended for the Migration Advisory Committee to 42,400. Not a huge increase, but an increase all the same. There is a change around what they call supplementary employment. Previously, you could do supplementary employment in the same profession, at the same professional level. That has gone. You're no longer able to do this. So you are just tied under this to doing the activities in the role that you are sponsored to do. It remains the case. There's no English language requirement. You don't have to establish that competency. Big question is, well, how useful is this category, particularly in light of these changes? And I think the intracompany route, what's going to be senior or specialist worker, is much less useful than it was under the pre-Brexit system, because under the new system, the skilled worker route, which replaced Tier 2 General, is much more flexible in terms of salary thresholds. Skill level is lower than it used to be to qualify. The advertising requirements in terms of the resident labour market test fell away. You've got shorter lead-in times when assigning certificates of sponsorship. So effectively, there's not many scenarios typically where you're going to be thinking, well, we can't sponsor for skilled workers, so we must look at ICT or senior or specialist worker, even for somebody based abroad in our group. So why would you use this, given that it's less flexible? It can't lead to settlement. So if the person comes to the UK and changes their mind, the time in this category doesn't count towards the 5 years for settlement typically required. I suppose the advantages are the no English language requirement. Probably the second main advantage is that the person can more easily remain employed by the overseas business whilst they're working in the UK. There can be some challenges and complexities around that in terms of remaining employed overseas when you are being sponsored in the skilled worker category of the UK sponsor. So I think in summary, my view is this is still going to be of relatively limited use to most businesses. In most scenarios, the skilled worker route will typically make more sense. That's subcategory 1. What about subcategory 2? Again, this is really just a rebranding. The graduate trainee replaces or rebrands intracompany graduate trainee. You'll be familiar with this if you use it. It's for graduate recruits transferring to the UK as part of a structured graduate training programme with a defined progression to a particular managerial or specialist role. Really, the provisions are unchanged. There's a slight increase in the minimum salary required by £100. Big deal, that's not huge. But that's not interestingly in line with what the Migration Advisory Committee recommended. The government is showing its thinking quite independently from what its official recommending body often suggests. You can't undertake supplementary employment, so no huge change on that second subcategory. Moving perhaps onto the more interesting routes. First of those, the third of these subcategories in this global mobility route is the UK expansion worker. I said that is new. It's really a replacement to the representative of an overseas business route that we have at the moment. And this is really designed for businesses who want to expand into the UK, but they're not yet trading in the UK. Might not be relevant for you at the moment, but stick with me because it could be relevant in future roles that you possibly have. You need to have a sponsor license again for this, but you can't be trading. Be interesting to see how the practicalities of that process play out. And you've got to be the subsidiary of an overseas business. And this is designed for overseas senior managers or specialist employees to come to the UK. In most circumstances, they need 12 months overseas service before doing so, essentially to establish the business in the UK. You can be here for up to 1 year initially and extend to a maximum of 2 years doing it. This is really the senior or specialist worker route, but for a business that doesn't yet have a UK operation that is trading. The provisions are very similar. So you've got the minimum salary of 42,400, like senior or specialist worker, or the going rate as published in the relevant code if that is higher. Again, doesn't count towards settlement. That is a change from the existing equivalent route that we have at the moment. So again, very much saying this is for short-term, sort of limited activities, not a long-term route into the UK. And there are no provisions here for high earners or longer leave. A few interesting points if you're into this sort of thing. There's no limit on the number of expansion workers you can bring into the UK. That's a change from the existing equivalent route. You no longer, as an expansion worker, have to have the full authority to take operational decisions on behalf of the business to be eligible to come in. Again, that's a change. And also you can, if you want, be the majority shareholder in the overseas parent company, which you can't be at the moment. Those of you who are good at flags will have noted my Japanese flag on the side, which is there to signify the UK-Japan Comprehensive Economic Partnership Agreement, where essentially there are special carve-outs for Japanese businesses. You don't have to have, for example, the cumulative 12 months overseas service before coming to the UK. So some exceptions as a result of that bilateral arrangement with Japan. I think that's quite interesting, not just by reference to this particular subcategory, but more in terms of the way that things are going generally, which is more bilateral arrangements with particular countries for global Britain in this post-Brexit age. And some of you might remember some of the youth mobility changes that have happened, specific arrangements for Iceland and India, for example. That seems to be the way things are going, possible carve-outs for particular countries in particular routes. So a route designed to enable overseas businesses to establish in the UK. Moving probably with increasing interest onto the two most relevant routes or interesting routes looking forward. The fourth one is the service supplier route, the fourth subcategory, which essentially picks up on the temporary worker international agreement route at the moment, often shrouded in apparent mystery, but with some quite important differences and could be quite significant. This is designed for 6-month assignments in the UK, but you can come to the UK in total for 5 years out of a 6-year period, as we touched on at the beginning. So you're not limited, as you are at the moment, for similar arrangements, to just a 12-month period in the UK. In total, you can be 5 years out of 6 years, albeit each assignment being no more than 6 months. This is designed for contractual service suppliers, and you may be in a situation as a business where you're looking to supply services into the UK internationally, and you're working out how can we do that. It's been difficult to date. What is a contractual service supplier? Somebody employed by an overseas service provider, or indeed somebody who is self-employed as an independent professional, and they're coming into the UK to provide services that are covered by a UK trade commitment. People kind of throw their hands up and think, what the heck does that mean? That all feels very complicated. The UK has a series of international trade agreements that essentially set out certain agreed services within them, and essentially if those services are covered in those agreements, then you can potentially make use of this route to come in. So for example, the UK-European Trade and Cooperation Agreement that was agreed between the UK and the EU has a table of services in it, for example, engineering, integrated engineering services, maintenance and repair of certain products. You know, if the activities are falling in those, then potentially this route is open and available for sponsorship. So we'll get further details in the guidance, but potentially a quite wide-ranging application to lots of different sectors in the economy. The overseas service provider can't have a presence in the UK, and there must be a contract to provide the services to the business in the UK, which must be that business on the sponsor license register, or there is a subcontracting arrangement to do work for the business on the sponsor license register if there isn't the direct contractual arrangement. So the sponsor has to be in that situation and be authorised by the Home Office to sponsor a service supplier. And the contract that the work is being done under has to be registered with the Home Office, which will be via the sponsor management system. Under the current equivalent rules, it talks about being pre-approved, and that's been a bit of a fiddly area. This is just registration. Whether that means it's going to be less onerous, less detail required, remains to be seen. We'll have to look at the guidance. Sticking with further details of the service supplier, how will it work in practice for people? You're going to have to be coming in to do work in one of the occupation codes listed as being a qualifying code in the appendix skilled occupations, or you can be somebody with a university degree or technical qualification with 3 years professional experience in certain sectors, or 6 years if self-employed. So it doesn't have to be you're in one of those codes. It could just be you've got appropriate sorts of qualifications for the services that you are providing. There's going to be a requirement to work for the overseas provider and have worked for them for a cumulative period of 12 months before the date that you apply, or if you're self-employed, having done 12 months working in the same sector. Precisely how that's going to work in terms of what would have to be evidence, we're going to have to wait to see with the policy guidance that comes out. question is, of what practical value is this going to be for many businesses in the UK? I think it has more flexibility than the current temporary worker international agreement route, particularly, for example, for the amount of time, 5 years and 6 years, that a person can spend in the UK providing services, being provided by a business to do that, or on their own self-employed basis. That is quite a big change. I think the rest of it, we're going to have to wait for the policy guidance to come out. There's still a question around, well, what about providing services to somebody who's not a registered UK sponsor? I'll look at that in a moment, but there's still potentially a bit of a gap there. What about if the service provider's got a UK presence already, which many businesses will do? It doesn't really work for that particular scenario because you can't have a UK presence. And it may be that the sponsored routes that you have, let's say the senior professional option that we looked at earlier, just isn't really relevant or appropriate for the sort of work that is being done in the UK. So there are still potentially some kind of lacunas there, I think. And also we remain to see how usable will it be in terms of registering these contracts that people are working on. Is that going to be relatively easy? Is it going to be tricky? How user-friendly will the guidance be on indeed the agreement that the services have to come under in terms of the international treaties the UK has entered into, so that employers day-to-day can just access that in a user-friendly way? That remains to be seen, will hopefully become clearer. Perhaps a gap that is being filled on some of those points is this final category in global mobility of the secondment worker. And this really, I think, is designed to cover the scenario that we've got at the moment where the visitor rules just do not adequately cover many of the activities that people coming into the UK need to do. They're very restrictive, the visitor rules, around the sort of activities that you can do, payments you can receive, length of time that you can be in the UK, uncertainty about being refused entry if you come as a non-visa national. This, I think, is designed to try and deal with some of those gaps and is new and I think welcome. I think this is probably the most significant change in many respects under this new route. But we're still awaiting some of the details. So you've got to be seconded to the UK and be sponsored by a sponsor as part of a high value contract or investment. What is obviously a high value contract or investment? Key question. The Migration Advisory Committee said that ought to be in excess of £50 million. Now that has not been detailed in the new rules at the moment. Will we get detail in the sponsor guidance? We should. But if it is £50 million or anything like that sort of threshold, you're still going to have the scenario where there's lots of contracts that people need to work on and service in the UK that are well below that threshold. And where do you end up? You've still got a bit of an unsatisfactory state of affairs and potentially having to look again at the visitor rules and all of the inadequacies of that route in terms of what they provide. There's no minimum salary requirement other than national minimum wage thresholds. Again, the role's got to be in an eligible occupation in the codes that are published. You've got to be working overseas for the business that's got a contract with the sponsor in the UK. And again, the contract has to be registered with the Home Office. How will that work, as we said, in practice? And there's got to be a 12-month overseas work requirement. You can, with this secondment worker route, come with your family members, though. And bearing in mind the point I said before about the 5 years and 6 being in the UK, it is significant because it means that people at the moment who are thinking, well, I don't want to come into the UK to work, on a short-term basis, when in practice it's difficult for me to bring my family with me. This is to some extent addressing that because of the family member options that are available. Permission is up to 1 year, extended to a maximum of 2 years. But as I say, it can be in total, a total of 5 years out of 6. So I think some quite welcome changes here. This could be quite significant for international businesses trying to get people in and out of the UK working on big contracts, but we need to watch this space on the guidance that is going to come out. So that's the global business mobility route going live on the 11th of April. What else is on the horizon in terms of new routes later this year? A couple that I think are worth flagging. And again, the government's quite excited about these in the statement of changes that they published. The first is the high potential individual, as they call it, going live on the 30th of May this year. A slightly curious route. I think this one, I'm not entirely clear in my own head exactly how attractive it is, but it's designed for overseas university graduates from top 50 global institutions to come to the UK. The government's going to create a list drawing on 2 out of 3 global tables in order to assess those 50 institutions. And I guess it's going to be fluid as time goes on. You've got to have a bachelor's or above equivalent to the UK bachelor's in the past 5 years from one of those institutions. And you can then come to the UK in order to work. There's an English language requirement, financial requirements apply. You can come for 2 years or up to 3 years if you've done a PhD. But it doesn't lead to settlement in the UK, although it may well be that you can switch into other routes whilst you're here, and you can work in any role or indeed be self-employed, so no salary thresholds, no skill levels. The question is, I mean, who really is going to use this route? What is the attraction? Will it be a quicker entry to the UK? You can bring your family with you, but given it doesn't lead to settlement, you know, you're quickly going to want to get out of it if you want to do anything sort of long-term in the UK. The innovation strategy the government published in July last year, so the government's going to continue to explore the scope to extend eligibility to other characteristics of high potential individuals. So we're going to have to watch to see whether this is further developed and expanded. It may be a bit like the global talent route has been consistently tweaked and fiddled with over the past couple of years, and actually is very different to what it looked like, with many different avenues for endorsement than used to be the case when it first came into play, I think February 2020. Final route is the scale-up route. This is the one that goes live on the 22nd of August this year, as it stands at the moment. This is also quite interesting, but again, I'm not sure how much value it's going to be if you're sitting there thinking, should I register as a sponsor with this route? You can register if you've met certain growth thresholds for the previous 3 years. That's annualized growth in turnover or staffing of at least 20% for 3 years. I think that means average growth of at least 20% for each of the previous 3 years, and you must have had 10 employees at the start of that 3-year period. But for this route, the minimum skill level to qualify is level 6. That's a higher skill level than level 3, which is the minimum skill level for the skilled worker route. And the salary requirements are higher. It's going to be the higher of 33,000 or the going rate. So more onerous salary requirements than the skilled worker route, where there's more flexibility under the tradable points options. So the English language requirement, as you might expect. And the interesting bit is that you get initial permission for a 2-year period, but you only need to be sponsored for the first 6 months of that period in the role that you've been sponsored to do. You can then be unsponsored after 6 months and be doing any work at any skill level or any sort of salary threshold thereafter, and it leads to settlements in the UK, I think, after 5 years. So I suppose again, the question is, okay, just sitting there thinking, well, why should we use this route? What is the potential attraction? I think, yeah, well, good question. I'm not sure about that. Could it be a way to get people into the UK if you're in a scale-up scenario more quickly with reduced costs and hassle, because you don't have to sponsor for as long? You sponsor for a bit, then they can be employed without being sponsored. That saves administration risk and cost, but then they're not tied to you in quite the same way. Is there an increased flight risk in what is obviously a very hot recruitment market at the moment? So we'll have to see what the guidance says on it. Lots of businesses, interestingly, may well be in the scale-up territory. You don't have to be a classic scale-up business to be growing at 20% annualized growth over a 3-year period. Lots of very well-established businesses are doing that. So potentially lots of businesses are in scope for this. Could it be a lower admin way of getting people in and sponsoring them initially and not having that on a longer-term basis? In terms of the future, the government said they're going to look at whether scale-ups can apply for those that show the expectation of strong growth, not just the track record, and they're promising a review on that. So again, this is not something that's going to be set in stone forever, potentially reviewed, subject to change, very dynamic, like much of the rest of the immigration routes that we've got at the moment. Increased diversification, lots of rules and changes in each route. So although there are more routes, more diversification, more flexibility, also more complexity potentially to be having to navigate. So that's a bit of an overview of the statement of changes the government published in March on the new routes. And as I say, we will get the policy guidance, I think, published in the next few days, the global business ability, let's hope, and over the coming months for those routes coming in May and August this year. Just a bit of a roundup before we pick off any questions or themes that have cropped up in the Q&A feed. What else is there worth saying? I think there's lots of stuff going on around Ukraine, and it's having quite a significant impact, I think, across the piece in terms of sort of UK visa issues. We've obviously got two routes for Ukraine nationals. So that there's a Ukraine family scheme, people that can come into the UK if they've got family here already, and also the much talked about sponsored humanitarian route, which is still very much working itself out. So sort of we're in phase one at the moment in terms of individuals being able to bring people into the UK. It looks like that could be expanded to charities, other organisations, potentially businesses could have a role to play in some form in this as the different phases play out. It's interesting, I think there's some slightly unattractive aspects to that I've picked up. So the government's not doing a huge amount to match people, well, not really very much at all, to match people up. And I've heard bits and pieces around sort of almost like a kind of dating app type approach where you kind of look at pictures of people, do you fancy bringing these people in, and people getting rejected because of, people in the UK not necessarily keen on the details that they get. I mean, that's not to criticise people who've signed up to the scheme, obviously, but I think, there's some quite difficult issues in there that are still going to be worked through, and I suspect that will change quite a bit. We've been doing some pro bono work as a firm on the Ukraine Advice Project, so providing some pro bono advice to people looking to come into the UK and what's obviously a really tragic situation. In terms of the work context, I mean, both of these routes are for 3 years. It's not clear at the moment, I don't think, what will happen after that 3 years, whether people can extend or indeed switch to other routes, but work will be allowed in both of those routes, and that is relatively unusual for what you term a humanitarian route, because the asylum route is typically not allowing work for people whilst they're waiting a decision on their application and they're in the UK. And that obviously is one of the points of contention that's been raised in Parliament over the past few days, as that bill, Nationality and Borders Bill, is going through. So in terms of sort of people applying for roles, it may well be, depending on the numbers that come to the UK is going to be attractive, both because of our record in many ways and because of the English language dimension for many Ukrainian nationals. There could be a lot of people coming in who will be, very highly skilled in the work that they do, because Ukraine is a, developed European country in so many ways, as well as potentially people coming in who may be able and willing to do roles that are deemed to be less highly skilled. So it could have a significant impact on the labour market, depending on the numbers coming in. It's also having an impact on the service standards for other visa routes. So as you may know, if you're regularly working with employees, you have the normal service standard, and then you can pay extra to have a priority service or a super priority service. Priority within 5 working days, super priority in theory within 1 working day. Both of those services are being suspended at the moment just due to the volume of work involved in managing the Ukrainian routes. What that means is, practically, if you're planning recruitment and visa issues, people coming in to take up roles, it's a longer lead-in time to start time. So out of country, you could be looking at, a 3-week processing time or thereabouts, possibly longer. It could be, 8 weeks or thereabouts in the UK. So certainly longer times without the options available to pay more for shorter turnaround times. So that's Ukraine. I think lots to develop in that area, tragically in so many ways. I wanted to touch very briefly on ATAS, because ATAS is often raised as an issue. This is the requirement for people engaged in many research roles in higher education institutions to have to get clearance from the Foreign and Commonwealth Office if they are going to be researching in particular areas of research designed to prevent the proliferation of weapons, to overseas regimes. And it is fair to say that the way that has panned out at the moment is not very satisfactory. And I do get questions on this quite a bit. The requirement to get ATAS clearance for an individual from the Foreign and Commonwealth Office does, the appendix to the immigration rules for ATAS make clear, only apply in respect of people who are being sponsored for a role by a sponsor who also has a student sponsor license. So basically, universities who have a sponsor license to sponsor workers. That is clear from the rules. It is also clear from the process guidance on the Home Office website. It's confusing because there are obviously other routes like the global talent route where you can come in and research in the UK and you don't require ATAS clearance. That does seem to be a loophole. It doesn't make sense, but the rules on that are clear. And I don't think it is appropriate, in my view, to be requiring individuals or asking them to get clearance where the immigration rules specify that's not required. And indeed, that could well take you into difficult territory around discrimination issues. I suspect this will get tidied up because it doesn't internally make sense, but it remains the case, for example, that somebody with a global talent visa researching in the UK does not require ATAS clearance. Think about sponsorship and hybrid working. The sponsor license guidance is very thin on the new ways of working. It takes a while typically for the Home Office to catch up with these things. We're moving into a very different working environment with hybrid working, people working at home. Have a think about that. Have a think about where your employees are going to be working. If they're spending a lot of time at home or their place of work has changed, should you be making a note, change of circumstance report on the sponsor management system, thinking about how you will deal with these issues on a compliance audit. Just be starting to think about those. I suspect we will get better policy guidance on this as the months unfold, but at the moment, it's an area I think to move towards the top of your radar so that you can meet and evidence you're meeting your sponsor compliance obligations, for example, around monitoring and enforcing in this new world of agile and hybrid working. Long term, the government is saying much about a new digital border by 2025, so the ending of documents and biometric residence permits, everything being digitalized, nothing being physical. That's increasingly being rolled out, and it will continue to do so, with the idea essentially of having a fully digitalized border by 2025. That will probably play back, as Mark was saying earlier, to more digitalization of what employers have to do in many areas. And linked to that, as I've said in many of the previous sessions we've done, there's ongoing work still with a new sponsor management system. Some of you may be engaged in feeding that to the Home Office on the new portal and how it's working, but we are promised a more user-friendly portal potentially later this year or next year, which will be much more intuitive, much better to navigate than the existing sponsor management system, which is essentially a bolt-on or bolt together of various slightly unsatisfactory IT provisions, it seems to me. So that's all I wanted to say proactively. We've deliberately allowed just 3 or 4 minutes or so to try to pick up any questions or themes that might be in the Q&A before we finish, as I say, 2 or 3 minutes before the hour. So Mark, I don't know whether there's anything in the Q&A that we can pick up and deal with.
Yeah, so there have certainly been some themes in relation to questions, particularly around the right to work points that we were discussing earlier. So just to try and kind of pick up on a few of those in broad terms to cover off as many of the questions as I can. We've had quite a few questions in relation to EU nationals, and it's specifically the point around, well, what if we, the employer, simply don't know that an EU national has failed to make an application to the EU settlement scheme? It remains the case that there is no need for employers to conduct retrospective checks on individuals who have been employed from before the 1st of July 2021, so before the end date of that scheme. So if you have EU nationals who were employed with you prior to that, and perhaps you conducted a right to work check on their passport, for example, which you were permitted to do at the time, that's fine. You don't need to proactively check what their status is now. The right to work check that you conducted at the time was absolutely fine and remains so. Obviously, from a practical perspective, if that individual comes to you now, then the points I was raising earlier will apply. And they need to be obtaining status under the settlement scheme if they haven't done so already. There may also be some policy decisions around kind of running something of an audit yourselves in relation to the situation. As time goes by, I suspect that will be less relevant and of less use. But the bottom line here is employers are not required to follow up or check with EU nationals whose status and whose right to work was checked prior to the 1st of July 2021. And then another theme, just to kind of clarify and expand upon some of the points I was making in relation to the online checks. To be clear, when conducting an online check, you are still required to check the details of the individual. So in the same way that you would if you were conducting a manual check, for example, you check the passport, you check that the pictures matched, for example, that the details are consistent with what the individual has told you. And you then retain a copy of that. The exact same applies in relation to the online check. So you're going to be expected to be on a video call with the individual, check that they are who they say they are, or rather that you are satisfied of that. You're not expected to be a detective, but just check that everything seems to be okay. And also you can then download a PDF to kind of retain as evidence of the fact that you did complete the check on that date. There is an audit trail that kind of sits behind the Home Office system. So when you're conducting a check using a share code, that is going to stick on the Home Office system, but you as the employer need to keep your own records. And so you need to be downloading that PDF as well.
Great, just a couple of themes that I'll pick up from looking at the Q&A feed. Someone's raised a question about, well, what about sort of academia and collaborations? There's not much in it for them. I think you're right that the changes in the latest statement of changes are essentially around international global businesses. There have been recent tweaks to routes that do help sort of research and academia and collaboration. So the visitor rules have been tweaked, for example, to the permissible activities for scientists and researchers, permitting research to be undertaken in the UK in a wider range of circumstances than used to be the case. And I think there've obviously been quite a few tweaks to, for example, global talent routes, the PPE activities that apply. So I think that's going to continue to evolve, but you're right, there's not so much for that sector in these changes. Someone's asked about the skilled worker visa. Just to be clear, that remains, it's not being abolished. That remains in play and will continue to be the main worker route, visa route for many sectors. And just to confirm a point that we did pick up earlier, but for late joiners, the IDSP, right to work checks, is that mandatory? No. The IDSP, the ability to do these digital checks for the service provider on British and Irish nationals, that is an option if you want to continue to do checks using the hard copy documents under the COVID concession until September, and then from the 1st of October in the usual way as you've always done. That remains an option, and I think for many employers that will still be the one that makes sense, because there will be hassle, cost, administration, and potentially some risk associated with using IDSPs that may simply be disproportionate in the circumstances. I don't know, Mark, whether there's any final points you wanted to pick up from the Q&A.
Nothing that we have time for, Alex, I don't think.
Okay, perfect. Well, that just leaves me to say thank you very much for joining us this morning. As I say, we will send the slides out this week. It's been great to have you with us. Hope you found it useful. Do feedback on any topics that you'd like for future sessions, and we'll try and make sure that we weave that in. But otherwise, thank you and have a great day.